Good afternoon, Your Honor. We are hearing case 25-CR-892, State of Ohio versus Andrew E. Toms. Present in court is the defendant, who is accompanied by his attorney, Ms. Nicolette Tomaszek. It is the state's understanding that the defendant is prepared today to waive indictment and proceed and plead guilty to a one-count information, that count being aggravated possession of drugs, a felony of the 5th degree with an attached forfeiture specification, and there is no, the defendant also has filed a motion for intervention in lieu of conviction, which the state does not oppose at this time. Thank you, Your Honor.
Thank you. Ms. Tomaszek, would you like to be heard on your motion?
Yes, thank you, Your Honor. We did file the intervention in lieu of conviction motion based on Mr. Tom's criminal history and the charges. It does look like Mr. Tom's is eligible for intervention in lieu, so we would just like to ask the court to grant that motion today.
Thank you. So, Mr. Toms, your lawyers filed a motion for intervention in lieu of conviction. I'm sure she'll probably explain to you what that entails, but I'm going to do the same at this point. What that motion is that it alleges that this offense was committed due to a drug dependency issue. And she is requesting that you be placed on a period of rehabilitation. And if you successfully complete that period of rehabilitation, the case gets dismissed. And you won't have this conviction on your record, which is a pretty big deal these days, not having a felony conviction on your record. I know you have a couple other prior convictions, but you don't have any prior felonies. So obviously this would be significant. And because it is such a extraordinary remedy, courts don't go along with this all the time. It's a big deal. So tell me why you think you should be granted this request.
Thank you, Your Honor. So throughout my life, I battled alcoholism. And up until about COVID, I started using illegal drugs, mainly from depression and my codependency issues. And I was an architect down in Columbus for about 15 years, and after I got involved in drugs, I gave up, and myself, I sought treatment, so I moved up to Warren, Ohio to seek treatment, which I completed, but unfortunately, this past May, I got complacent with the situation I was in, and I relapsed. And there was really no excuse other than complacency, and I thought I could do this alone. Fortunately, it may be unfortunate, but fortunately, I look at it as a blessing that during my relapse I got arrested and charged with this felony possession because I was honestly, I needed help, and being incarcerated there here in Paynesville is kind of where I had my spiritual experience, and I knew that I couldn't do this alone, that I needed help from not only God but my peers that I've surrounded myself in Warren, because Warren is has a great recovery community, and I've surrounded myself with them. I'm very much involved with them now. I'll say again, but it was truly a life-changing experience. Being arrested for what I was arrested for, and I 100% want to get sober. Like, that is my main goal right now, is to maintain my sobriety and give back to the community that has helped me through these rough times.
Well, if I grant your motion, you're going to have to follow the rules of probation, the conditions I impose. The way it would work is I would accept your guilty plea but not find you guilty of the charge. I'd stay any further criminal proceedings, including the sentencing and the actual conviction, and put you on a period of rehabilitation with the probation department where we would put together an intervention plan. And if you complied with the terms of that plan, and the conditions of probation, and the rules of probation, I mean, then at the end of that period of time, the case would be dismissed. So one of the factors or findings I need to make is that you are able and willing to, and you're amenable to following the conditions of the intervention plan. Are you able to do that? Will you do that?
Yes, Your Honor. I've been, once I got...
No, I just
released-
wanted to hear your answer
I
there.
apologize.
All right. Well, I have reviewed the pre-sentence report investigation, the drug and alcohol evaluation that was completed. And looking at all that, I find that you are eligible for intervention in lieu of conviction, that each of the factors set forth under 2951.041B are satisfied. So I'm going to grant your motion for intervention in lieu of conviction. Now, before I can officially grant it, you need to plead guilty to the charge and the information. So I'm going to go through that with you, but in order for me to accept your plea, I have to ask you a series of questions. So we're going to do that. It'll take a little bit of time. If at any point when I'm asking you these questions, if you're unsure or unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer so you can ask your questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything that's going on here, all right?
Yes, Your Honor.
All right. Well, let's get started then. How old are you, sir?
I'm 42 years old.
Are you able to read and write the English language?
Yes, Your Honor.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
I do not.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this afternoon, have you any drugs or alcohol of any kind?
No, I have not.
What about in the last 48 hours?
No, sir.
Not even prescribed medication, nothing?
Nope.
Now, did you receive a copy of the information that was filed in this case? That's the document that sets forth the specific charge you're accused of committing?
I have, Your Honor, yes.
And did you have the chance at some point to read that and review it?
Yes, Your Honor.
Now, in that information, you are charged with one count. What is alleged here is on or about April 16, 2025, in Painesville Township, Lake County, Ohio, that you did knowingly obtain, possess, or use methamphetamine or some compound mixture, preparation, or substance containing methamphetamine. That's a Schedule II controlled substance. The amount involved did not equal or exceed the bulk amount, which makes the offense aggravated possession of drugs, a felony of the 5th degree. Do you understand what you're charged with and pleading guilty to in this count?
Yes, Your Honor.
Any questions about it?
No, Your Honor.
Charge also carries with it what we call a forfeiture specification, which alleges that you possess or hand interest in property considered to be contraband or an instrumentality. Contraband is property that's illegal just because of the nature of the property, like drugs. In this case, the contraband that's alleged that you had is the drugs, it's the methamphetamine. The whole point of this is that you forfeit any ownership interest that you have in the property. It permits the court or the prosecutor or the state to be able to dispose of the property. Any questions about that?
No, Your Honor.
Well, then before I can accept your plea, I need to make sure you understand all the rights you're giving up by pleading guilty. And you first of all have a right to have a trial. Now, a trial could be to me as a judge, or I listen to all the evidence and I make that decision. Oh, I have to go back to the grand jury first. I'm sorry. Thank you, Mary. Let me stop for 1 second. I skipped ahead for a moment. The document that I just read to you, the information, we call that an information. And what it is, it's a criminal charge brought by the prosecutor's office without the case having previously been reviewed or considered by a grand jury. What a grand jury is, it's made up of a group of citizens here from Lake County that get together and they meet privately. They meet in secret for the purpose of evaluating evidence in cases to determine whether probable cause exists that someone committed a crime. Probable cause we define as some evidence that would suggest that a person probably committed a criminal offense. Everyone here in Ohio accused of a felony has the right to have a grand jury independently review the evidence in a case and make a decision without the government being involved in that decision whether someone should be charged or not. And you have that right as well, but you can give up that right if you desire and go forward on the charge brought by the prosecutor and the information. And your attorney has indicated she believes that's what you want to do. Is that correct?
Yes, Your Honor.
Well, before I could go any further, I need to have you acknowledge that here in open court in writing. And I have in my possession here a one-page document called a waiver of indictment, which sets forth what I've just explained to you about the grand jury process, and it indicates you want to give up that right. Before I can go any further, I need to be assured you understand this document and that you sign it here in court. My understanding is before I came out here, you had a chance to go over that document with your lawyer, is that correct?
I have, yes.
Ms. Tomasic, is that accurate? Did you review this with your client, read it over with him, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you when you did that?
Yes, Your Honor.
Is that correct, Mr. Toms?
Yes, sir.
So you understand what this document says?
Yes, Your Honor.
Do you have any questions for me about it?
I do not.
Now, it also appears that you signed the document. Did you in fact sign it?
Yes, I did, Your Honor.
Ms. Tomasic, you witnessed that?
Yes, Your Honor.
Ms. Himmeline, you too?
Yes, Your Honor.
All right, I'll make that part of the record. So at this point now, Mr. Toms, I'm going to review with you all the other rights you have that you're giving up by pleading guilty. And first off, you have a right to a trial. A trial could be to me as a judge, or I listen to all the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. A jury trial would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be unanimous. Unanimous means all 12 of them would have to agree together, one way or the other, whether you're guilty or not guilty. You understand by pleading guilty, you're giving up your right to have a trial in this case?
Yes, Your Honor.
Now, if we did have a trial, the prosecutor here would represent the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation of proving you guilty before you could ever be found guilty. You are presumed innocent of the charge, and the presumption of innocence sticks with you and stays with you until the state, if at all, was ever able at a trial to overcome that presumption and prove you guilty. Do you understand that?
Yes, sir, Your Honor. Yes.
Now, when I speak of this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt, which is the highest burden we have in our justice system. What it actually means, it's the amount of the evidence and the quality of that evidence the state would have to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element or each part of the criminal charge beyond any reasonable doubt before you could ever be found guilty of this charge at a trial. Do you understand that?
Yes, Your Honor.
You understand by pleading guilty, you're giving up your right to make the prosecutor prove you guilty beyond a reasonable doubt at a trial?
I do, Your Honor, yes.
Now, to do that, or at least try to do that if we had a trial, the prosecutor would call witnesses to come to court to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same persons questions. We call that cross-examination. She could ask them anything she wanted to within certain rules. Do you understand that?
Yes, Your Honor.
Now, you would also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. You don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
Yes, Your Honor.
And you further can request the court issue an order. That order is called a subpoena. What a subpoena would do is force or make someone come to court to testify for you and answer your lawyer's questions if there was anyone out there that wasn't willing to come in voluntarily on their own. Do you understand that?
Yes, Your Honor.
You realize you're giving up that right?
Yes, Your Honor.
Now, you'd also have the right at a trial. You could choose to testify on your own behalf if you wanted to, but you do have a constitutional right not to testify if you don't want to. That is a decision or a choice that you would have to make. Do you understand that?
Yes, Your Honor.
And since that's solely your choice, what that really means then is that nobody else could force you or make you. Nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify, but more importantly, the prosecutor here, she would not be permitted to call you as a witness at your trial and make you get up on the stand and answer questions and testify. Your own lawyer couldn't make you testify if you didn't want to. Do you understand that?
Yes, Your Honor.
You further understand that if we went to trial and you were found guilty of this charge, you would have the right to appeal or challenge that guilty finding to a higher court, a court that sits above me and reviews my decisions. By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding. This court will enter if your plea is accepted, as well as any other issues you could have raised or brought to my attention up to this time. Do you understand that?
Yes, Your Honor.
All right, then, do you have any questions at all about these rights we've just discussed? These are all the rights you have and all the rights you're giving up by pleading guilty. Any questions?
Not at this time.
Understand them all?
Yes, Your Honor.
You know, and just a moment ago, I misstated something. I said that by pleading guilty, you're giving up your right to appeal the court's finding of guilt. And you're not going to be found guilty initially of the charge if by granting this motion. Now, if you fail to comply with the terms or conditions of the intervention plan, you would be found guilty of this charge at that point. So, again, you're waiving your right to appeal that guilty finding if it should come down the road. You understand that?
I understand, Your Honor.
So make sure they say it the right way. So do you still want to plead guilty at this time?
I do, Your Honor.
Now, you
yes.
understand a guilty plea is a complete admission of guilt, so it means you're admitting to the facts being alleged by the prosecutor. We don't argue later you didn't do this or it's someone else's fault or anything like that. Do you understand that?
Yes, Your Honor.
Further, as a result of pleading guilty, the effect of a guilty plea normally is that you're found guilty by the court and then you're subsequently sentenced. That won't happen with the court granting an intervention in lieu of conviction. What will happen in this case is that I'll accept your guilty plea, but then I'm going to impose a stay on all further criminal proceedings. I'll place you, again, under the supervision of the probation department for a period of time, and I'll implement an intervention plan with certain rules and conditions for you to follow. If you follow those rules at the end of the period that I've imposed and there's no violations, the case will get dismissed. If you fail to do that and you fail to comply with the rules, a motion to terminate your intervention in lieu of conviction will be filed. And if after a hearing it was found that you did in fact violate the rules, at that point I would lift or vacate the stay of criminal proceedings. I would find you guilty of the charge and we would then proceed to sentencing. So I need to make sure you understand what the potential sentences could be if we ever get to that point. We obviously hope we don't get to that point, but if we were to get to that point, I need to make sure you understand ahead of time what potential penalties you could be facing if that happens. So I'm going to review those with you at this point. And if we did proceed to sentencing, the offense you're pleading guilty to is a felony of the 5th degree, and it's punishable by a possible term in prison of a minimum of 6 months, a maximum of 12 months, or any whole number in that range of 6 to 12. You understand that?
Yes, Your Honor.
I believe I know the answer to this, but I'll ask anyway. Are you currently on probation or parole to any of the courts or agencies?
Yes, Your Honor.
You're on probation for that assault charge?
Yes, Your Honor.
I need to let you know that there could be consequences with that court as a result of having committed this offense and pleading guilty to this offense. Nothing I'm going to do about it or that I have the authority to do about it. But they could have, if you commit a new crime when you're on probation, there could be a violation. You could have consequences there. You understand that?
Yes, Your Honor.
Right. Do you have any other charges pending against you right now?
No, Your Honor, no.
If a prison sentence is ever imposed upon your release from prison, you could be placed in what is called post-release control. It's sometimes called parole. And that's a period of supervision you would be on after you served and completed this sentence. This particular case, it could be up to 2 years. Do you understand that?
Yes, Your Honor.
And if you were on post-release control and you were violated any of the conditions of your supervision, they would have a hearing. The parole authority would have a hearing to see if you did violate their rules, and if they found that you did, they could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term was imposed by the court. Do you understand that?
Yes, Your Honor.
Now, aside from the possible prison sentence I just explained, there could be other sanctions that would be ordered at the time of sentencing. Some, in fact, will. You will be ordered to pay court costs or reimburse the county for any costs of confinement, community supervision, or treatment, if any that were applicable in this case. Do you understand that?
Yes, Your Honor.
Further, if we did proceed to sentencing, you could be fined up to $2,500. You understand that?
Yes, Your Honor.
Also, since this is a drug charge, I could suspend your license if we proceed to sentencing. Not today, but if we proceed to sentencing. I could suspend your driver's license up to 5 years. Do you understand that?
Yes, Your Honor.
Lastly, as I mentioned about the forfeiture specification, any right you have to the contraband will be forfeited to the state of Ohio. Do you understand that?
Yes, Your Honor.
Now, a few moments ago, I explained what the possible prison term would be if we had to proceed to sentencing. I used the word possible because prison wouldn't be mandatory with this case. You would be eligible at that time for probation, what's called community control sanctions. Do you understand that?
Yes, Your Honor.
Do you understand that just because you would be eligible doesn't mean you would automatically be put on probation? It means I will consider that, if that's what you'd be asking for at the time. Certainly I'm going to look at the reason why we're back here and what happened with intervention in lieu. But then I would make the decision at that point that I thought was the right thing to do. Do you understand that?
Yes, Your Honor.
Now, if you were put on probation, it could be up to 5 years. As the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions could be an order that you serve time in the Lake County Jail as a condition of probation. Do you understand that?
Yes, Your Honor.
Further, if you ever are on probation, you violate any of the conditions of your supervision, there would be a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years. I could impose more restrictive sanctions against you, or I could terminate or end your probation and send you to prison at that point. And if I did it then, again, it could be 6 to 12 months in prison, and that could be consecutive to any other prison sentence you may be serving for some other case that may occur, or that you're being sentenced to at that time. You understand that?
Yes, Your Honor.
All right, well, do you have any questions regarding the potential penalties you could face if we ever did have to proceed to the sentencing hearing?
I do not.
You understand all the possible consequences?
Yes, Your Honor.
Do you still want to plead guilty?
Yes, Your Honor.
Have you had enough time to talk about this case with your lawyer, have her review everything with you and answer your questions?
I have, Your Honor, yes.
Are you satisfied with the advice and counsel of your lawyer?
Yes, Your Honor.
Have you been threatened or coerced in any way by anyone to enter this plea of guilty?
No, Your Honor.
Are you entering the plea freely and voluntarily?
Yes, Your Honor.
All right, then, do you have any questions for me at this point regarding anything we've talked about concerning the rights you're giving up and the potential penalties you could face?
I do not, Your Honor, no.
You need any more time to talk with your lawyer before we go forward with your plea of guilty?
No, Your Honor, I do not.
All right, then what we're going to do at this point, the prosecutor here is going to explain for me what she believes the evidence would establish at a trial if we had a trial. I want you to listen to her because then I got some questions for you about that, all right?
Yes, Your Honor.
Simone.
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on June 16, 2025, at approximately 9:30 p.m., the defendant was in Painesville Township, Lake County, Ohio, when a Lake County Sheriff's Office patrol officer observed the vehicle being driven without taillights and operating with hazards on. Additionally, there was only one functioning brake light. The vehicle was, a traffic stop was initiated on the vehicle. The defendant was the passenger in the vehicle, although he admitted ownership of that vehicle. While speaking with the defendant, he did grant consent to search his person. In his front left pocket of his jeans, officers located a Ziploc bag with a white and brown crystal-like substance. The defendant admitted that the substance was methamphetamine. It was sent to the Lake County Crime Lab for testing and confirmed to be 1.80 grams of methamphetamine, an amount less than bulk. Thank you.
Mr. Thomas, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes, Your Honor.
What, if anything, do you have to say about those facts as she presented them? Are they true? Did you do what she said?
They are true, yes, Your Honor.
Very well, then, regarding count one, charging you with aggravated possession of drugs, a felony of the fifth degree with the forfeiture specification, what is your plea to that?
Guilty, Your Honor.
All right, I have in my possession here another document. This is a 4-page document that sets forth everything we've just discussed regarding the penalties you face and the rights you're giving up. Before I can accept your plea, I need to make sure you understand this document and that you sign it here in court. Again, my understanding is before I came out here, you had a chance to go over this document as well with Ms. Tomazik. Is that correct?
Yes, Your Honor, it is.
Ms. Tomazik, is that accurate? Did you read this over with Mr. Toms, review it with him, answer his questions?
Yes, Your Honor.
Did he indicate an understanding of it to you?
He did, Your Honor.
Is that correct, sir?
Yes, Your Honor.
You understand what it says?
I do, Your Honor,
You have any
yes.
questions for me about it?
I do not, Your Honor.
It also appears you signed this document too. Is that correct?
Yes, Your Honor.
Ms. Tomazik, you witnessed that?
Yes, Your Honor.
Ms. Simone?
Yes, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with his lawyer advised of all his constitutional rights, and made a knowing, intelligent, voluntary waiver of those rights. Court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea of guilty to count 1, aggravated possession of drugs, a felony of the 5th degree, in violation of 292511 of the revised code, with the forfeiture specification. While I'll accept his plea at this time, I won't find him guilty. I am going to grant the motion for intervention in lieu of conviction as I indicated. I'm going to order a stay of all further criminal proceedings. I'm going to place the defendant under the supervision of the Lake County Adult Probation Department for a period of 2 years, and I'm going to order the implementation of the following intervention plan. I'm going to order that you serve 9 days in jail. You have credit for 9 days, so there's no further time that you need to serve. I'm going to order that you continue with your intensive outpatient treatment, continue residing in the sober living residence that you are at. You are not to use any drugs or alcohol. That includes marijuana. You shall submit random urine screens whenever requested. They must be negative. A positive screen is a violation. Can't tamper with the urine sample, bring fake urine, someone else's urine, anything like that as well. It's even worse than testing positive, quite frankly. You're to attend 3 AA meetings a week, have a sponsor, obtain and maintain full-time employment. 1 doctor and 1 dentist, 1 pharmacy, which means you can only have 1 doctor that prescribes you medication. If you have a specialist, that's fine too. But make sure probation knows who your doctors are that give you prescriptions. You can only get them from them. You can only fill them at 1 pharmacy, so make sure they know that pharmacy as well. You need to sign whatever releases they want you to sign also. If they need to contact any counselors, any doctors, you need to sign those for them. You're to pay your court costs and supervision fees. You're to take all medications as prescribed. You're to forfeit the contraband and the listed in the indictment and the specification. You don't have to have any contact with Alina Zentner or Catherine Robertson. You got somewhere to be?
No, I was my probation email.
I'm sorry?
I just got an email from Ashtabula County Probation.
Did you hear what I said in the last condition?
Yes, Your Honor.
No contact with either of the 2 co-defendants here. At this point, he's going to be supervised by Lake County. I want to see how that goes for a little bit, and then we can consider transferring that. Is there anything else I should consider, Ms. Randazzo?
Your Honor, I know he's being prescribed mental health medication through general pharmacy, but I'm not sure if he's receiving any actual mental health counseling. Are you seeing a counselor or just being prescribed medication?
So it's through telehealth, through Elizabeth Johnson. So once a month we do telehealth counseling.
We'll have to continue with mental health counseling and follow recommendations also. Understand that?
Yes, sir.
So do you understand all the conditions of the intervention plan that I just ordered?
I do, Your Honor,
Any
yes.
questions for me?
I do not, no.
All right, I need to advise you if you fail to comply with any of these conditions, any of the rules of probation, which they'll go over with you. Do you want them to go over there now?
Yes, Your Honor.
So you're going to go to probation after here and meet with them and go over the rules with them. If you do that, if you commit any other crimes going forward from here, or if you leave Ohio without permission from this court, a motion to terminate your intervention in lieu of conviction would be filed. If it's found that you did violate, I would lift the stay of criminal proceedings that I just put in place. I'll find you guilty of the felony charge. It'll be on your record. And then we'll proceed to sentencing, where anything I just explained to you regarding the potential penalties you face by pleading guilty could be imposed, which includes going to prison for 12 months. You understand that?
Yes, Your Honor.
All right. Anything else for the record, Ms. Timline?
No, Your Honor.
Just a couple things, Your Honor. With regard to the full-time employment, Mr. Toms did just get a job at Goodwill. It is for 30 hours a week. However, he is in school at Lakeland as well.
That's fine, it's full-time, all right, so full-time education, full-time employment and education. So combination of those two is what I want to do for you, for your purposes of being busy full-time. The whole point is to keep yourself busy. So yeah, if you're going to school and you're working part-time, that's fine too, but on a full-time basis, you're working, going to school, or some combination of those two.
Thank you, Your Honor. And then just one more thing, just for the record, I know there was conversations in chambers regarding Mr. Tom's license. And speaking of Mr. Tom's, he does have his license reinstated. He paid his fines off a few weeks ago, retested, so his license is valid
All
as
right,
of
good.
now. Thank you.
Good. Thank you for sharing that. Simone, anything else?
No, Your Honor.
Thank you.
Thank you, Your Honor. Reporting today on State versus Brandon Brewer, file 17 CR 561. We're here today for sentencing. State of Ohio has had the opportunity to review the pre-sentence investigation report and is prepared to go forward. Thank you.
Thank you. Mr. Urank, any reason not to go forward with sentencing?
No, Your Honor. We received a copy of the pre-sentence investigation, had an opportunity to review it. No additions, changes, or deletions.
Anything you would like to say on behalf of your client or present on behalf of your client?
Yes, Your Honor. After speaking with Brandon, he's advised me that his intention is to go to CDL school. Part of his motivation for this is he has a 3-year-old daughter at home, and he is very excited to get back home to Detroit, Michigan. That way there he can be a part of her life. In my communications with him, his biggest fear is to be removed from her for any length of time. Additionally, Your Honor, he tells me that she has been an inspiration for him making better choices going forward. To that end, Your Honor, that's part of the reason why he's stayed out of trouble. This event occurred in, I believe it was 2017. Since that time, Your Honor, he did have one issue in 2018. But since that time, Your Honor, he has stayed out of trouble. He's served some weeks worth of credit on this case. His mom is here today.
He served what?
I believe he has a couple weeks of credit on this case. He's been sitting in the
This
jail.
has like 89 days.
Yes.
Close to 3 months.
Yes.
It's more than weeks.
My note here says weeks
Sure,
back in
Mr.
September. His mom is here with a letter from his girlfriend, I believe also the mother of his child. She would like to address the court. I'll save the remaining balance of my comments until after Mom has spoken and addressed the court.
Sure.
Mom, if you would stand.
So you can just stand right where it is that you're seated. State your full name and spell your last name so our court reporter gets that down accurately. Then you can say whatever you'd like me to know.
Good afternoon. My name is Latoya Brewer Pugh. What was it? Brewer is B-R...
Pugh.
P-U-G-H. And this is the letter from Miss Leah Walker.
How do you spell Leah?
L-E-A-H.
Thank you.
Dear Judge Culotta, first thank you for taking the time to read my letter. My name is Leah Walker, and I have known Brandon Brewer for about 5 years. Since I have known him, Brandon has been kind, responsible, and a natural leader. 3 years ago, we welcomed our daughter, London, and he has been the best father figure a child could ever ask for. I understand the seriousness of this situation and its impact on the parties involved. When you are young, you sometimes make impulsive decisions without fully understanding the long-term consequences. However, I do not believe that this mistake should define who Brandon is or what his future holds. The person Brandon was at the time of this incident is not the same man I know today, and certainly not the man I chose to be the father of our child. I truly believe this experience has been a turning point for Brandon. We've discussed his record on several occasions and genuinely thought this case had been resolved long ago. That is the only reason he did not take care of it sooner. Otherwise, he would have. This arrest came as a complete shock to us all, especially since Brandon had just started attending school to obtain his CDL. Meanwhile, I just completed nursing school, and together we were planning a brighter future for ourselves and most importantly for our daughter. When Brandon isn't working or in school, he spends all his free time with his family. He is a hands-on and loving father, and his absence is deeply felt. There isn't a day that goes by without London asking for her father. She does not deserve to become one of the 1 in 4 children who live without their father due to a youthful mistake made long before she was even born. Your Honor, I respectfully ask that you take this letter into consideration when making your decision. I believe Brandon has learned from this experience and has the potential to continue contributing positively to his family and community. Thank you for your time and understanding. Respectfully, Leah Walker.
Thank you. Is there anything you wanted to say? You don't have to. I just want to make sure everything's been said. That
I just want to say that I totally agree with all the statements that Ms. Walker said in her letter. The Brandon did these crimes years ago was not the same Brandon that's sitting here now. He's completely did like a 360, especially since he's had his daughter. He loves her and she loves and misses him so much, and we just want them to be back together as a family.
Thank you. Mr. Brewer, you have the right to address this court before you are sentenced. You can say anything you like. Is there anything you want to say at this time?
Yes. I got a couple sentences that I wrote down as well. I want to apologize to the city of Willoughby and Lake County for coming out here doing what I did May 5th, 2017. Also to my family, my little girl especially, getting her caught up in my mess. It was my fault for prolonging the situation. I was a kid, scared to face my consequences for my actions. If I could take it all back, I would, but I can't. So I'm glad to be standing here today so I could close this chapter in my life and move on. So I could get back to work, return to school without looking over my shoulder, but most importantly, continue being a father/role model to my little girl. And that's all, Your Honor.
Thank you. Mr. Urinka, anything else you'd
Just
like to
that
say?
we're hopeful that Mr. Brewer will be released soon, given his credit for time served, given the time since this event, and given how he has changed since this all transpired. Thank you.
Thank you. Guy-Rich for the State of Ohio.
Thank you, Your Honor. State of Ohio choice of court fashion, that's appropriate in this matter. Thank you.
Well, this court did review the pre-sentence report and investigation that was completed. I've considered the facts and circumstances of the offense involved and nature of the offense, the history of this case, and what's been said here today by Mr. Urinka, the defendant himself, defendant's mother, and the letter that was written from his girlfriend, prosecutor. All this is considered under the purposes and principles of felony sentencing set forth in 2911 of the revised code. As for the factors in 2912, the court finds the defendant did act as a part of organized criminal activity. No factors indicating it's less serious. As for recidivism factors, the court notes the defendant does have a history of criminal convictions prior to this offense occurring. He had, at the time this happened, had not been responding favorably to previously imposed sanctions. He violated his bond and disappearing, left, absconded, and didn't show up for court hearing. He was gone for 7 years. Now, your girlfriend made a comment that you truly and honestly didn't know. But the words out of your mouth show that that's not the case, because you said you're finally excited to be able to go forward without looking over your shoulder. Well, you wouldn't be looking over your shoulder if you thought it had all been completed and there was nothing going on. You knew what was going on. You knew you didn't show up. Felonies just don't disappear in the wind and go away. You were charged with a felony, you didn't show up, and they just don't go away. It never came to court, it never got resolved. But the fact of the matter is you absconded and you left. The factors indicating recidivism is less likely, yet it doesn't appear that there is anything since 2018, though there was another crime after this occurred when you were on the run. But this is not the way things work. You don't get charged with felonies and then be able to leave and then become good and then say, well, I don't deserve to be punished at all for this anymore because I've turned my life around. You didn't comply with bond. You didn't face the consequences when they occurred, when this incident was pending, and you left. And things just don't go away and disappear. Felony of third degree, there's no presumptions either way in regards to probation or community control. The fact that you just left, up and left, and are gone for 7 years, there's no way this court could ever make a finding that you're amenable to community control sanctions. Oh, and the other point I needed to bring out, I'm sorry, is that once you were in the jail, pretty shortly after getting in the jail, you get disciplined because you and some other inmates are making hooch in the jail. I never had one of those discipline infractions before. As soon as you got into jail, you basically committed that. Within a couple weeks, you made that violation. I'm not sure what that's all about and why you would do that if everything was turned around. But the court can't make any finding that defendants amenable to community control sanctions. Prisons consistent with the purposes and principles of sentencing. Therefore, it will be the sentence of this court that in the lesser included offense of count 1, defendant served a term in prison of 12 months. He has credit for 89 days he's already served. I need to advise you upon your release, you could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating the rules for another 6 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release controls being imposed as part of the sentence at this time. Court disapproves the defendant's placement in any program of shock incarceration, intensive prison program, or transfer to transitional control. And the defendant's ordered to pay all costs, and all remaining counts of the indictment will be dismissed. Bond has been previously revoked, so it's not to be released. Mr. Geiger, anything else for the record?
Nothing, Your Honor.
Mr. Uranka.
No, thank you.
We're here today in the state of Ohio versus Linda Akoff, case number 25CR1096. The defendant is present counsel Chad Mulkey, and we're set today for a sentencing hearing. We were last before you on September 30th, and at that time the defendant pled guilty to count 2, robbery, a felony of the 3rd degree, and to lesser included count 3, attempted felonious assault, a felony of the 3rd degree. During that hearing, a pre-sentence report and victim impact statement were ordered. A pre-sentence report has been completed, and a victim impact statement has been returned. The defendant has 107 days of jail time credit. Thank you.
Mr. Mulkey, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Yes, Your Honor. Thank you. Your Honor, my client is 30 years old. Throughout her life, she's indicated to me, and I think it's evident from her pre-sentence report, that she has an issue and struggles with drugs, including starting with alcohol at a young age, marijuana, cocaine, crack cocaine, ecstasy. Your Honor, and we'll note that she has a lot of prior misdemeanor theft convictions. There's a felony receiving stolen property, but a lot of this stems from stealing items and things to support her habit. Your Honor, she wanted me to ask this court for help getting her addiction under control. Specifically, she mentioned a placement at Nora House. She indicated to me that there is a bed available there. Also on her mind are her 2 young children, ages 2 years old and 9-month-old. I'm sorry. She does not currently have custody of either one of them. She wants to get with Job and Family Services to coordinate putting a case plan in place, and she believes that with the help of Nora House or a similar agency, that she can get on track to being reunited with her children, getting her drug addiction under control. She can get that under control. She can stop committing thefts, and she can take care of these outstanding warrants. I did discuss those with her. She wants to resolve those municipal warrants as well, get into housing, and leave the life of drugs and theft behind her, Your Honor. So again, being only 30 years old, she's got a lot of chances left to demonstrate to the court that she can lead a law-abiding life and to be a productive member of society, Your Honor. Thank you.
Thank you. Ms. Akoff, you have the right to address this court before your sentence. You can say anything you'd like. I did receive your letter, and I read that. But you have a right to speak in court, too, if you want. Is there anything you want to say?
I would like to apologize to the clerk and to you for being here. And that's it.
Is there anything else you'd like to say? You don't have to. I just want to make sure you said everything you want.
That's it. That's everything.
Mr. Mulkey, anything else?
Not at all, Your Honor. Thank you so much.
Ms. Bell for the State of Ohio.
Thank you, Your Honor. I had the opportunity to review the pre-sentence report in this case, and while the defendant doesn't have a lengthy history, she does have a history with many petty thefts, misdemeanor thefts, and that's what this case really should have been. And the only reason we're here today is because the defendant chose to escalate it with violence. Violence that that resulted in the victim fracturing one of her fingers. It didn't have to be that way. It could have, stopped at any point before escalating to violence. So that's really troubling to the state. The state would also mention that the defendant has a history of probation violations, and that she was on bond while this offense happened. The state would ask for a prison term in this case. Thank you.
Thank you. This court did review the pre-sentence report and investigation that was completed in this case. Consider the facts and circumstances of the offenses involved, the nature of the offenses. I've considered what's been said here in court by the defendant, her lawyer, the prosecutor. As I alluded to, I did receive a letter from the defendant. I've read and considered that. All this is considered. In light of the purposes and principles of felony sentencing set forth in 29:29:11. As for the factors in 29:29:12, the victim did suffer an injury here. It's not necessarily required to commit any of these offenses, but she did, and it was unnecessary. Nothing makes it less serious. Problem here is the recidivism factors. Almost all of these are present. The defendant committed this offense when she was on probation. She was on probation in the South Euclid Municipal Court. She was on bond to the South Euclid Municipal Court. She was on bond to the Cleveland Heights Municipal Court. On bond to another case in the Shaker Heights Municipal Court. She's got a history of criminal convictions, including a prior felony conviction, which interestingly started off as an aggravated robbery case, but it got reduced to the receiving stolen property. In that case, there were multiple probation violations for the defendant just not showing up, tampering with the GPS unit when she did have it on. She committed multiple offenses while she was on probation before in the past, so she's failed to comply with previously imposed sanctions ordered by the court. There's a history of that, history of probation violations. Just a history of not showing up. You just don't go to court. You got warrants all over the place for you. I don't know why you don't think you have to go to court to address them. That you can just do what you do, get your bond, and then just blow it off. But that's what your whole history here is. I don't know how you expect me to listen to what you say and saying I'm going to follow up everything you tell me to do if you put me on probation and give me this chance. When you look at the history and you've never done that before, you don't do it. You violate. You've got warrants out of Shaker Heights, Cleveland Heights, South Euclid, East Cleveland. All because you don't go to court.
I didn't have a place to stay though, but now I do. And
What's that have to do with not going to court?
I didn't get no mail.
Well, did you call the courts and ask what's going on with my case?
No.
You knew you had cases. You got arrested. You got charged. Got cited. I'm tired of people saying that I didn't have a way to get to court. And that could be true. Sometimes people have difficulty getting to court, but there's no reason that they can't call, make a phone call. That would at least legitimize, perhaps, that there's some issue. If I wasn't living where I was living when that happened, I'd probably call the court and say, you know what, I'm not there anymore. Do I have a hearing set on this? Those are all factors indicating recidivism is more likely. There's really no genuine remorse in regards to the offense itself. She admits that she stole the cigarettes, but she basically says it was the victim's fault in regards to any violence that occurred. No factors indicate recidivism is less likely. These are felonies of the third degree, which are not subject to any presumptions. When we consider the nature of the offenses involved here, we're talking about a robbery and attempted felonious assault. And then the defendant's history in terms of how she has performed before in the past on probation. and all the warrants out for her. There's no way this court can find she's amenable to community control sanctions. Prison's consistent with the purposes and principles of sentencing. Therefore, it's a sentence of this court that on count 2 and the lesser included offense of count 3, defendants serve a term in prison of 12 months on each count. They'll be served concurrent with each other. You have credit for, what's the credit? 107 days. Need to advise you upon your release from prison, you may be placed on post-release control, or you will be, right? This is offensive violence. You will be placed on post-release control for at least 1 year. It could be up to 3 years. When on post-release control, if you violate any of the conditions of your supervision, the parole authority can send you back to prison as punishment for violating their rules for another 9 months for each violation you commit, up to a maximum of 50%. So in this case, it would be 6 months. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court will dismiss the balance of the indictment. The court further disapproves of the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. Release bond. I think that covers it. Ms. Bell, did I miss anything, or is there anything else we need to address?
Did you mention costs and fees or anything?
Well, I'm going to impose costs. I thought I said it, but maybe not. No fees, no, because it's not probation, but just costs, court costs. Smoke, anything else for the record?
No, Your Honor, thank you.
Thank you.
All rise.
We're here in the matter of the State of Ohio versus Michaela B. Wells. This is case 25 CR 937. Ms. Wells is present in court. She is accompanied by her attorney, Ms. Nicole Novotny. She was last before the court on the 30th of September, where she pled guilty to one count of failure to comply with an order or signal of a police officer, a felony in the 4th degree. At the time of the plea, the court ordered a pre-sentence investigation report along with a psychological evaluation. Those having been accomplished and delivered, we're here today for sentencing.
Thank you. Ms. Novotny, any reason not to go forward with sentencing?
We may go forward, Your Honor.
Is there anything you want to say on behalf of your client?
Yes, Your Honor. At this time, we'd like the court to consider Ms. Wells for community control. She understands after going through this whole process that she made a terrible decision on the date of the incident. She takes full responsibility, as she has stated in the pre-sentence report, with her actions. She regrets driving away, and she knows that ultimately her driving away has led to much worse matters. Your Honor, she's only 19 years old. She graduated from Invictus High School. Additionally, she has been working since then. She's been working since 2022 at Woodside Senior Living as a nursing assistant. Additionally, Your Honor, in the meantime between her employment and now her incarceration, she was accepted into La Barberia. She does pursue and wants to pursue ultimately becoming a barber. I know her admission date, she did try to start that off, but ultimately it has been deferred to January, from my understanding, with the letter based on what was submitted to the court. So she does like to pursue becoming a barber in the future. Additionally, Your Honor, she does have her own LLC for her own clothing line company that she does intend to keep pursuing as well in the future. She has a lot of long-term goals, Your Honor. She's very young. She ultimately wants to pursue those in the right direction. I know she's experienced a lot of trauma, especially with the death of her grandmother. Your Honor, during that time when she was in hospice and became very ill, she was taking care of her at that time. So she was her personal caregiver. Her grandmother.
I know. What time was this?
It was around the time that she was supposed to turn herself in for the information offer. Her grandmother was unfortunately dying and in hospice.
So when was that?
The day she passed, well, the funeral was on September 12th. She passed.
Was what?
It was on September 12th.
September 12th?
That was the funeral, yes. Okay. But around the time when the incident happened, that's when I was caring for her.
I know on the date of the incident, Your Honor, what she explained the situation, she had medications for her grandmother, which ultimately led to her decision to drive off. With that, Your Honor, she is seeing mental health counseling and med compliance with Dr. Amy Coleman with University Hospitals. She does want to continue with that aspect of it. I know, Your Honor, just through my conversations with not only Ms. Wells, but also her mother, she does have a lot of family and friend support with backing her up. Ultimately, numerous letters were submitted to the court for your review, and she does have that support system when she does return to society. We're just asking for the court to consider her for community control at this time.
Ms. Wells, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say?
Yes, Your Honor. Thank you for the opportunity to address the court. First and foremost, I take full responsibility for my actions that have brought me before you. I want to deeply apologize for the choices I have made. I have spent a great deal of time reflecting on the decisions that led me here, and I can honestly say that I have learned my lessons from this experience in a way that has changed me. Since being incarcerated, I have taken every opportunity to grow and prepare for a better future. I have obtained my LLC and have been working on building my small business that I plan to continue working on once I am released. I am also committed to finishing barber school and obtaining my barber license. While working steadily as a way to support myself and contribute positively to my community, this time has allowed me to realize what I truly want for myself, and that is to live with purpose, integrity, and accountability. I know that one mistake doesn't have to define a person, and I'm determined to prove that I am capable of change and deserving of a second chance. I am not asking for leniency as an excuse to avoid responsibility, I'm asking for the opportunity to continue the work I have started and to rebuild and make things right. I want to be a productive, reliable, and positive member to society. I am truly remorseful and will carry the lessons from this experience with me for the rest of my life. Again, I would like to apologize to the courts and my family. I understand the damage I've done. I was going through a rough patch in my life mentally, but I'm ready to do better and get my life back on track.
I guess I don't get the second chance business. You're on probation for 2 felony charges when this happened. And
Yes.
you got a chance then. You committed more crimes. I mean, you're only 19 years old. When's your birthday? Let's see here.
I just turned 19, September 29th.
Just turned 19, right?
Yes. Can I say something else?
In a second.
Alright.
So you turned 18 in September of 24, right?
No, 24. Yeah, 24, yes.
October 11th, felony theft charge. October 28th, felony theft charge. October 28th in another county of the state, felony theft charge. October 31st, assault charge. So within a month, oh wait, what's that? November 4th, attempted theft. They reduced it for you from a felony theft charge in Cuyotta. So within the first month of turning 18, you picked up 3 felonies and 2 misdemeanors.
Yes.
Doesn't seem like you learned any lesson to me.
During that time, I was going through like a lot.
What were you going through?
Like I was kicked out just on the streets, nowhere to go. As soon as I turned 18. But after I got I got a job and started working. Like after I got put on the probation. But like at the time it is.
You did what?
I had got a job. I've been working since.
And then what about probation?
Like when I was put on probation, like I went to see my PL every time. I never didn't go.
There's 7 warrants out for you right now because you don't show up to anything.
Well, yeah, the reason I have a warrant with Warren and Butler because I have a no.
You have 7 warrants out for you. Not all from the same county. 7 different courts around the state have warrants for you.
Yeah, I know the. Can I explain them?
Sure.
The Cuyahoga County one, that's a probation violation for being here.
Okay.
And then the Mayfield ones and the Shaker one, I wasn't aware until I got in here. I rent my car out like under my parents' LLC. They have a rental car business. So like for those ones, my license plate was captured. Like, and I was supposed to take my car there, but
So wait, what about your parents with this rental car?
they got an LLC. They rent cars out.
Okay.
So
how's that connected to you?
yeah, so my car is rented out under their thing. Like, my mom had to go get a power of attorney thing. Like, I don't know if y'all can see, but, like, my car was in Lake County impound at the time.
Your Tesla, right?
Yeah, it was in Lake County impound. And that's why I couldn't take the car. So the detective issued a warrant because I couldn't come bring my car, like, for them to get fingerprints from the person that was renting my car. I haven't been in front of them or anything yet. So, with Shaker and the other one.
So you went to Invictus High School in 2024?
Yes.
Where's that?
It's on Euclid Ave.
Where were you living then?
In Euclid with my mom.
I thought you said they kicked you out.
Yeah, after I graduated.
When did you graduate?
I graduated in June. I graduated before I was 18. I graduated when I was 17. June the 24th.
So where do you live?
Well, I'm going house from house right now. Like, I live with my friends from time to time. I don't have a set location. And plus, the house that my mom in Euclid, it was in a house fire, so it's doing remodel.
What's your mom's name?
Tiffany Hahn, she's president in the court, actually.
She what?
She's president in the courtroom, too.
So you kicked your daughter out when she was 18?
Yeah, she couldn't follow rules, so my sister did let her come stay with her for a while, but I don't know what happened with that situation.
Well, is there anything else you want to say?
No, that's all.
Ms. Novotny, anything else?
Nothing further with that respect, Your Honor.
Ms. Mulligan for the state?
Your Honor, the state does not think that the defendant is amenable to community control. She was on probation at the time she committed this offense. She's only 19 years old, and as the court noted, she already has a criminal history. She failed to appear for proceedings in this matter. We believe a prison term is appropriate.
Well, here's what I'm confused at, because when you met with the probation officer, you told them prior to your arrest you lived at 26201 Shoreview Avenue in Euclid.
Yes.
You've lived there since you were 10 years old.
Yes.
It's a house owned by your mother. You lived there with your parents and brothers.
Yes. That's the house that had a house fire. But I also told
Okay, so and you're returning to that address upon your release, though you're going to move in with a friend at some point. Doesn't say anything in here about being kicked out of the house, not living there, not having a place to live. You've lived there since you've been 10 years old.
Yeah,
And you currently still live there, and that's where you lived before you were arrested.
I put that I was living at 6614 Fullerton. Also, like when
You put what?
that I was living like at a friend house at the time, 661 Fullerton. I told
That's what she told you? You have that information?
She mentioned a different address at which they were temporarily staying because there was a fire damage to the home, but I didn't include it because it seemed very short term and she had intended to move back to the other place.
So why do you tell them you've been living at that house with your mother since you were 10 and you were living there before you were arrested, when apparently you hadn't been there for a year? At least 9 months before this incident happened.
What?
You got kicked out in September. You went on this crime spree. And you apparently weren't there well, you've never been back there.
I did make it known to my attorney that
I'm sorry?
I did make it known to my attorney that I wasn't living with my mom.
I don't care about that. You went to the probation department and and I told you need to be open and honest with them. Why did you tell them that you were living with your mother this whole time? I never hear it. This is the first time I'm hearing that you were kicked out of when you were 18, and that's why you committed all these crimes, which isn't an explanation or excuse for committing crimes.
Well, when I talked to probation, I did mention the house fire. I didn't say, I mean, like, that's the address I was living at. Like, that's not like where I live. Like, I go house to house. But the house I've been living at before I got arrested was 6.
Prior to arrest, you lived at 26201 Shoreview Avenue, and this is all from you. She doesn't know this stuff. She can only write down the information she's provided from you.
I understand that.
And you told her that you've lived there since the age of 10. You did this when you were 19.
Yes.
So over a year after you supposedly were kicked out of the house. You live there with your parents. You're going back there. Nothing else about not having any place to live.
Yes, so when I got picked up, I was picked up from 661 Fullerton Ave. That's where I was staying. I was not staying at Shoreview. That's where I plan to go when I am released. They're going to let me come back.
Why did you tell probation you were living there since you were 10 years old? You've lived at that residence and that address.
I mean, because that's where I'm going when I go back. But the house was under remodel, so my mom wasn't living there at the time either. We was going from Airbnb to Airbnb. I let my attorney know that as well. She was going from Airbnb to Airbnb. She didn't have a set place to live either.
You didn't meet your attorney until June of this year.
I know I'm saying.
This is in September of 24,
September 24.
when you turned 18. I asked you earlier about all these crimes you committed all over the state. That within the first month of turning 18, you had 3 felonies and 2 misdemeanors. And you blamed that all on not having a place to live. And according to what you told probation, you've been living with your mother.
I haven't. I got kicked out when I was 18.
This court has considered and reviewed the pre-sentence report and investigation, facts and circumstances of the offense involved, the nature of the offense. Consider what's been said here in court. I received numerous letters in support of the defendant. I've read and considered all of those. All this is considered under the purposes and principles of felony sentence. I gotta ask you one more question. So where did you work before you went to jail?
Woodstock Senior Living, nursing assistant.
And how much money did you make there?
$15 an hour.
So the probation department report says with $1,500 a month. Does that sound right?
Yeah.
How do you drive a Tesla?
I got a business as well. Like, I got a clothing brand that moves steadily.
And how much money do you make off of that?
I make about like $3,000 a month off my
So
clothing.
why isn't that a part of this probation report?
I'm not
We supposed to just know that? No. I mean, there's nothing in here about that you have this business that you're making $3,000 a month at?
I understand. Well, when I got my car like probably in like April, but I put $0 down on it. I didn't.
You have $1,000 a month that you pay in your loan.
Mm-hmm.
So you only make $1,500 a month. $1,000 goes to your loan. $700 goes to rent. What rent? Who are you paying rent to?
When I stay with my friend. When I was staying with my
All
friend.
right, so that's $1,700. You got another $100 you pay between 2 phones, or at $1,800. Car insurance is $350, so that's $2,150. Gas, $160, so that's $2,400. Credit cards, another $100, $2,500. Then apparently you have some court costs and restitution. So your monthly obligations are $2,500 a month, and you make $1,500 a month. I don't get how that works.
Sometimes I like at a nursing home.
I mean, I want to know because I'd love to love to be able to do this too.
At a nursing home, I work like overtime, so we get paid time and a half. I don't do it like every month, so like my base pay is $1,500.
You work like 120 hours a week?
Yeah, you could do that. You could do that at a nursing home. You could work however many hours.
And you do that?
Well, not every week, like, but sometimes I do it my
So
business.
why didn't you tell probation about this?
I'm not sure. I should have. I didn't know. But I got like big statements and all that, like from my business. Like I got an LLC with my clothing brand.
What's the name of this clothing brand?
Get Money Apparel.
What is it?
Get Money Apparel.
You make $3,000 a month on that,
Yes.
plus the $1,500 a month at the nursing home?
Yes.
So you make $5,000 a month almost, $60,000 a year.
Yes.
I'm not sure how you have a public defender representing you. If you make that much money, why are you just living on the streets, not having a place to go every night, nowhere to go? Well, as I mentioned, I consider all this information in light of the purposes and principles of felony sentencing set forth in 29-29-11. For the factors in 29-12, nothing stands out factually indicating the conduct is more or less serious. However, with this offense, I also need to consider the factors in 29-21-331B, which are factors in making fleeing and eluding charges more serious. In this case, the court notes that, in every fleeing and eluding, there's a risk of physical harm to people. But in this case, you did it and took off right when the police officer was right next to the car, and he literally had to jump out of the way in order to avoid being hit and injured. He then drove on the shoulder of the road, passing several vehicles that were there in order to get away. Those factors make this more serious, put people at serious risk of harm. As for recidivism factors, the court finds the defendant has a history of juvenile delinquency adjudications as well as convictions as an adult. There's a delinquency adjudication as a minor for an assault, as well as receiving stolen property. Then became an adult, and as I summarized earlier, there's 5 convictions, 3 for felonies within the first month of becoming an adult. She has failed to comply with previously imposed sanctions ordered by courts. She fails to appear for court. She doesn't go. There's 7 warrants out for her. I've never seen anything like this for someone that wasn't even 18 at the time when all this stuff happened. Or was just 18, I should say. I'm sorry. I just turned 18. 7 warrants for failing to appear at courts. So she doesn't comply with court orders. She failed to appear for court in this case, which is a violation of her bond. She was on probation to the Cuyahoga County when she committed this offense. She was out on bond to multiple courts when she committed this offense. Those are all factors indicating recidivism is more likely. Nothing indicates it's less likely. She actually got arrested for a fleeing and eluding charge 2 days after she did this one. That case is still pending. That's one of the warrants. Under 29-29-13B1, the court again finds the defendant committed the offense while on probation. That is a factor that overrides the presumption for probation and permits the court to impose a prison sentence. without having to overcome any presumption and make any findings. Prison, based on the history, is certainly consistent with the purposes and principles of sentencing. The question is whether you're amenable to community control sanctions. I'm having a real hard time finding that you're going to follow rules. I have nothing to base it on because your whole history is not following rules. And I can't disagree with one thing the prosecutor said in regards to the recommendation of prison. But Ms. Wells, I'll give you one chance with this court. It's only one chance. If you fail to report to your probation officer one time, you're going to prison for 18 months. Now, if you're in custody somewhere at some other court, fine, we'll find that out. But we'll know the minute you get released from wherever you're released. And if you don't report to your probation officer, you're going to prison for 18 months. And I'm pretty sure that's going to happen because that's what you've always done. Now, you can prove me wrong, and I'll be happy to be proven wrong.
Yes.
I'm going to put you on community control sanctions for a period of 2 years. I'm going to order that you serve 75 days in jail. You have credit for 46 you've served. Further conditions, you are not to use any drugs or alcohol. You must submit random urine screens. They must be negative. A positive screen for anything, including marijuana, is a violation. You shall not tamper with or your urine sample, bring in fake urine, someone else's urine, anything like that. I want you to obtain and maintain full-time employment, provide proof of that in all of your employment. I don't want to find out you've said one thing and then later you've got all this other stuff going on. When you meet with your probation officer, you're supposed to tell them everything that's going on and the truth of what's going on. You don't just say, I'm living there because that's my mailing address, but I really don't live there. They're going to need to know where you're living. If you're living somewhere that they don't know about, that's a violation and you're going to prison.
Yes.
So if you move, you let them know. They need to know. They're going to go over all this with you, but we're not going to be playing games here. It may have happened in Cuyahoga County where there's other people that you're on probation to. It's not going to happen here.
Okay. You said, how many days did you say I accredited?
You have 46.
46 days of credit.
Okay. Okay.
To obtain and maintain full-time employment or education. If you want to go to school, you go to school. If you want to get some type of training, you can do that too. But on a full-time basis, you're working, going to school, or some combination of those two together.
Okay.
I want you to obtain a drug and alcohol evaluation, find out whether there's any issues that need to be addressed, and if there are, you need to follow those recommendations. If there's not, there's not. Your license will be suspended for 3 years. That's mandatory. I have no discretion in that. Well, I do have discretion. I could suspend your license for the rest of your life, but I'll do the minimum 3 years. But that's a separate sentence. But a condition of probation is you're not to drive a car or to drive any vehicle. So it's separate and apart from having a license suspension. Because license suspension is, only gets if the person gets cited for DUS is when we find that out. If we find out you're driving a car, that's a violation of your probation. Understand that?
Yes, would I be able to get driving privilege to work
you're
in
not
school?
eligible. Not eligible. So you have to figure out what to do with that Tesla. You're to pay court costs and supervision fees. I also want you to get a mental health evaluation and follow any recommendations for counseling, if any. Megan, anything else I should be thinking about or considering? Oh, and then last thing is you need to clear up all these warrants. So once you're done serving this sentence, I'm assuming someone's going to come and get you.
Is it a way I could take care of while I'm doing my time here? Because I know they were saying that to see her at the jail.
You're going to serve the 30 to 29 days you have left here, and then once that's over, the other counties are going to be notified that you're available to them, and they'll have to decide whether they're going to come and get you or not. If you
Okay.
can figure out a way to take care of them while you're here, do that. But you're not leaving here to go take care of those. You understand all the conditions of your community control sanctions?
Yes.
Any questions for me?
No.
I need to advise you, if you fail to comply with any of these conditions, any of the rules of probation, if you leave Ohio without permission from the court, or if you commit another crime going forward, I don't care about anything that may have happened in the past. So if you need to, if there's pending charges and you think it's in your best interest to resolve those by pleading guilty or admitting to something, you can do that. That's not going to be considered a new conviction that's going to terminate your probation. Understand that?
Yes.
So you do whatever you think is best in those cases. I'm talking about from today going forward if you do something else, a new crime. If anything like that should happen, a motion to terminate your community control sanctions will be filed. And if it's found that you violated, I could extend your probation up to 5 years. I can impose more restrictive sanctions, or I can and will terminate your probation and send you to prison. It will be 18 months in prison, which will be consecutive to any other sentence you may be serving at the time from some other court or that you're being sentenced to at that time. You understand all that?
Yes.
So what's going to happen if you don't report to your probation officer when you're supposed to?
I'm going to be violated and sent to prison.
And you're what?
I'm going to be violated and sent to prison.
Okay. Mr. Devotny, anything else?
No, Your Honor.
Ms. Mulligan?
No, Your Honor.
All right.
All rise.